Hello and welcome to Pensions in a Pod, a podcast series by Evershed Sutherland that keeps you informed on topical issues within the pensions and benefits world. I'm Jeremy Goodwin, partner and head of pensions, and in each episode within this series, we'll hear from speakers across our pensions and benefits team.
Hi everyone, thanks for joining us today. My name's Tim Smith. I'm a professional support lawyer in the pensions team here at Evershed Sutherland, and I'm delighted today to be joined by Emma King and Gemma Hanley, two partners in our pensions team. And we're here to talk about Section 37 and Virgin Media and what clients have been doing in response to the Virgin Media judgments that we had in June 2023. So Emma, Gemma, thanks for joining me.
Hi.
Yeah, hi.
So Section 37, everyone's been talking about it, certainly in the pensions world. It's obviously been a big deal since we had the first Virgin Media judgment back in June 2023. And just by way of reminder for anyone who's listening, essentially the court held in Virgin Media that if where you had a scheme that was contracted out between April 1997 and April 2013, if you didn't get the necessary actuarial confirmation when you made certain changes to the scheme, those changes could be invalid. And clearly, if those changes are invalid, that could cause real difficulties for schemes. So Emma and Gemma, how have clients been responding to this? What have clients been doing in your experience?
From my point of view, Tim, I've seen a real cross-section of responses to this. Some of our clients were early movers and decided to have a look at their deeds as soon as we had the High Court's decision. I would say those that didn't take that approach, since we've heard about potential solutions from the DWP in the form of a regulation under Section 37, and because we now know about the Verity Trustees case that's being heard in the High Court at the moment, those kinds of clients are adopting a wait-and-see approach because, in the hope that this actually goes away as an issue.
Yes, similarly to you, Gemma, I've got quite a mixed bag. I've also got a lot of clients who are sponsors, and their approach again has been mixed. The majority who've had a look, and mostly it's been a little look, just peeking under the bonnet, have been driven by auditors wanting to know what's been done, and a general consensus that at least looking at the archaeology of your deeds to see whether you've got confirmations where they're needed appended to the documentation, to have an initial look. But the question to my mind is then that is satisfying, I think, most auditors in relation to notes in the accounts. But then what do you do after that? And I think most sponsors and trustees are taking the view that if, given all the moving parts that you've just referenced, Gemma, actually, if you don't have to go any further, assuming you haven't got a clean bill of health, and there's some question marks around some deeds, actually, can you put it on ice and wait the outcome of these other activities that are happening? Because at the moment, I think it would be really difficult to actually ask an actuary to quantify what the additional liability would be, because we just don't know. And Verity Trustees might be quite helpful, depending when we hear something on that. And I don't know what's the likelihood on hearing the outcome of the Verity Trustee case.
I think in terms of timing, so I've actually been in court for most of the last 2 weeks, listening to the arguments around Section 37. I mean, the reality is Section 37 is actually a relatively small part of a much bigger case. So it's a 32-day hearing, 7 days on Section 37. So there's a lot of issues for the judge to get to grips with. I think in reality, I would have thought he'd be doing very well to get his judgment out by July before the summer recess. I think probably we're looking at the autumn. But as you say, Emma, it's going to be a really important decision and covering a lot of ground in relation to Section 37. And I think will shape the outcome of many of the reviews that have been undertaken. So I think that kind of pause and wait and see until we've got Verity Trustees in most cases is going to be the right approach. You mentioned auditors, Emma. And, certainly in my experience, we've seen perhaps a range of different responses from auditors, some perhaps pushing more strongly for reviews and, to really understand the issues, and some perhaps being willing to adopt more of a wait and see approach, or allow schemes and sponsors to do that. I'm interested for both of you really, just to see in your experience how auditors have been responding around this.
I think the position has been significantly helped by the recent statement from the Institute of Chartered Accountants in England and Wales, which recognised that some trustees were not going to be able to, fully quantify any additional liabilities, but having a little look and seeing certainly whether your scheme is affected in terms of whether it's a contracted out scheme within the relevant period, and having a look to see whether you do have any deeds that don't obviously satisfy Section 37. So I think that has helped, because it's almost said it's okay not to go, exhaust all possible avenues and quantify the potential impact. So I think that's helped. And obviously, we've recently had a statement from the Pensions Minister, Torsten Bell, and it seems very, very much on the government's agenda now, whereas only a few months ago, we were worried that it wasn't at the right level within DWP and receiving the appropriate attention of ministers. So I think there is cause for optimism there. But, some trustees and employers, in my experience, have been able to satisfy auditors by really just saying, we don't intend to have a look at our deeds. We haven't done so to date. We're aware of these two activities that we've talked about already, verity and potential regulation. We know that the schemes were well advised throughout the period by experienced pensions law firms, and we've got no reason to suspect that everything, anything was done that wasn't done properly, if you like. So we have had some success in taking that kind of approach, and that seems to have been adopted by some auditors. Having said that, there have been other sponsors who have felt, more compelled to undertake more detailed investigations. And I think, Emma, you've had some experience of that, haven't you?
Yeah, that's right. Anyone who has taken a look, in my experience, has actually stopped at the initial review stage and isn't necessarily chasing down documents within archives and such like. And I guess some of it depends where the scheme is on its journey. So I've got a number of clients who are looking at mergers. And again, you're being asked as trustees to warrant where you are with your scheme in terms of compliance. And if you haven't done any review whatsoever, that might be more challenging. And then there's others who are in the middle of doing benefit specifications to approach insurers. And you perhaps want a little bit more certainty if you're doing that sort of exercise around what it is you're asking insurers to price for. And then of course, there's the group who are in that phase between buy-in and buy-out, and that's another question entirely. So I do think it's relevant where a scheme is on its journey here.
Absolutely. We have a lot of clients at the moment who are between buy-in and buy-out, and they've secured the benefits on the basis of their understanding of what the scheme benefit structure is, without reference to sort of Section 37 kinds of issues, and they're looking for guidance, reassurance as to whether or not they can complete the buyout without having dealt with Section 37. I think if we can wait, if the buyout can be completed once we've known whether, what the verity judgment will say and whether there will be any action by the government, then so much the better. But clients are wanting to understand, well, what if we don't have certainty by the point we have to buy out? And I think really our understanding is that schemes are not going to be required, while ever there is a lack of legal clarity, to secure those additional benefits. But when you're talking to your employer about a potential indemnity, making it absolutely clear that this is one of the kinds of issues that could be called upon, that could call on that indemnity, and leaving the employer in a position whereby it could secure those additional benefits if it had to, and if there is legal clarity over whether or not there is a need to do that. Tim, I'm just wondering, the judge that's hearing the Verity Trustees case, do we know anything about their background? Are they pension specialists?
Yeah, so it's Judge Trower who's been hearing the Verity Trustees case, and he definitely has pensions experience. He's been on a number of pensions cases before, so it's not the first time he's had to kind of look at this area. And he was clearly very engaged, and got the arguments, I think, that were being put by the various parties. So that's good news in the sense that we have someone who's got some experience around this area. And yeah, I mean, as we've already alluded to, the outcome of that decision is going to be really important. So just at a very high level, it's considering things like, what's in scope for the purposes of these actuarial confirmations, which changes needed confirmation and which changes didn't. Looking at things like closure to accrual, whether that required actuarial confirmation, and also the extent to which trustees might be able to presume that things were done properly where perhaps evidence is lacking. So I think it's going to be a really important decision. And I think, as Emma said, I think where schemes can wait and see what the outcome of that is, and then perhaps if DWP take any action, that's probably the right next step for most schemes, I would have thought.
Yeah, I'm just hoping that the answers we get are pragmatic and helpful as opposed to purist and unhelpful. But there we go.
Yeah, I think everyone's got their fingers crossed on that one.
Yes.
And do we know anything about what a potential regulation under Section 37 could look like, or are we just in the realms of guesswork here?
I mean, I've heard a few different kind of ideas floated for what the government might do. Potentially the ability to perhaps for an actuary to give some kind of confirmation now, for example, that the relevant changes wouldn't have meant the scheme would have failed the reference scheme test. But I think all the solutions have I don't think anyone's come up with a perfect solution yet. And the other question I think that we need to look at very carefully if the government does intervene is the scope of that intervention. Does it validate all changes or only some? So it wouldn't necessarily be the silver bullet to solve everything, but clearly, if the government did take some action in this area, it would be helpful.
Yeah, it certainly would. It's just uncertainty. That's the problem. And you're right, Gemma, in terms of future buyouts, we can put it on a sponsor with an indemnity, because actually that more often they're being asked to provide an indemnity in relation to some element, because there's always some risk that you've missed somebody or the benefits aren't quite right, and it's just another element to that, isn't it? Mm-hmm. But it's quite a lot to ask all of those sponsors to bear, given the level of uncertainty. So yes, a little bit more clarity on this would be very helpful.
Yeah, well, I certainly think the Verity Trustees judgment will go some way to giving more clarity. I understand there may be some further cases that might follow on from that, so that they might offer some further clarity as well. And then obviously if we do get DWP intervention, that would help.
And Tim, just out of interest, and I know this is a podcast around Virgin Media, but it's a very long hearing in relation to that Verity Trustee case. Are there other questions that the court is being asked that we might find some other perhaps unanticipated and unexpected outcomes when we get that judgment in relation to other areas?
So just stepping back, the case itself considers various historic amendments that were made to schemes under the pension trust, and primarily relates to a fetter on the scheme's amendment power and whether or not certain changes were valid or not. And clearly Section 37 issues became relevant to that following the Virgin Media decision. So yes, it may have wider implications potentially, but they're also likely to be quite scheme specific, I would have thought, to the particular rules of the pension trust. And I think it's the Section 37 issues that are likely to be of more general interest and application.
That's reassuring. It's always one of those dangers, isn't it? You ask one question and you might get an answer to that, but in doing so, you open Pandora's box in relation to something else that you thought was settled.
Yeah.
Okay.
Great. Well, Gemma, thank you for that. I think really helpful insights into what's going on in practice around this, and really what schemes might do next, in light of the ongoing uncertainty, and the as you say, the activities that are going on in terms of Verity trustees and DWP intervention. So thanks for listening. Hopefully that's given you some food for thought and also some helpful guidance on kind of how to take this issue forwards.
Thank you for listening to the latest episode in the Pensions in a Pod series. Stay tuned for our next edition, where we will provide more perspectives into the world of pensions and benefits.